Hello, hello, hello. Let me know if you can see and hear me. Thank you for those people that are here with me so I can figure out this crazy thing that is called OBS and that is called a Mac update. And just in the chat, if you can see or hear me, go ahead and put it in there. Let me know. Let me know. Is anybody out there? It's a test. Hey, yay. Okay, you all are here. Woohoo. And so I want to thank you for being here. I'm not quite sure how long the feedback is, but go ahead and give me a thumbs up. I think what we've got going on is a little bit of lag, but that's okay. So I'm here. I'm going to play a sound. You all tell me if you can hear it. And in exchange, put a question that you have about real estate in the chat, and I will go ahead and I will answer it. Tell me what you hear. Uh-oh, looks like you're not hearing anything. But go ahead and put that question in the chat. Oh, good, you did hear the crickets. Oh, yay. Yay, 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 yay. It looks like there's just a little bit of a delay, but I am so excited. You are here, I'm here. Remember, this is to help you all if you have questions. So go ahead, put them in the chat. I'd love to help you with real estate if I can. Well, it's not a matter of if I can. I know I can. I know I can hear. I can help you. So go ahead, put it in the chat. Yeah, there is a lag, and I got to figure out what that lag is. But at least I have my sound back. Any chance, Loy, that you know how to go in and fix that lag? You hate types of ownership. Well, I'm going to go ahead and I'm going to talk about some different types of ownership, even though there is a lag. And you let me know if what I'm doing is helping. And you know what? We'll just be a little laggy. We'll be a little laggy, but I appreciate you being here. So let me scroll past this. And you said what you don't like is estates and all of that stuff, which, of course, that makes sense. So we're going to talk about it. Types of ownership. So when we talk about ownership, I'm going to make that smaller just so we can do it. Ownership means you have an interest in real estate. Right? So if you say you own it, that means you have some connection. So a lot of times I like to teach that an interest in real estate is a connection with real estate. What do I mean by that? Well, there's a difference between having an easement and owning something. When you own something, you know you get the bundle of rights. And that includes, the right to exclusive possession. But when you get an easement, you're just getting the right to use or to cross. It's not yours. You just have the right to use it or cross it, right? So both of those are interests. It's just when you own it, it's yours. When you have the easement, you can use it. When it comes to ownership, it turns out you got levels. And level number 1 is your strongest. And that's going to be, well, when you own it, the question is, how long do you own it for? You could own it forever. Or you could maybe own it forever. You were never going to own it forever. And 4 is you don't own it. Right? Whenever you were looking at estates and you were learning that vocab words, that is what you were talking about. If you're talking about types of ownership, what we're really saying is, do you own it? Do you not own it? What's going on? And then, how long do you own it? So ownership means freehold. Ownership is freehold. And if you own it forever, that's going to be a fee simple absolute. You own it forever unless you decide to sell it or you decide to give it away. And since you're not going to live forever, that means you can decide to will it to whomever you want, whether it's a relation or not. That's what we mean by owning it forever. Fee simple absolute. And I tell you, after you pass this class, all we want you to know is if that deed says anything besides fee simple absolute, you need to call an attorney or the title company or somebody because something else is going on. Right? Well, then our next step is going to be maybe you own it forever, and that's going to be your fee simples defeasibles. That's fee simple defeasible. So I'm just going to go down here. And your defeasable estates, I like to think of the word defeated. And by defeated, I mean ended. And what I'm saying is that your ownership can end. When you have a fee simple defeasable estate, it could be yours forever, but if you mess up, it's not going to be yours forever. Okay, so what do I mean by that? Imagine, I don't have kids, but imagine I had a kid and they were 17. In fact, I have a nephew who's 17. And let's imagine I bought him a car. And my one rule was you can have the car as long as it's your car, it's your title, it's in your name, it's all paid off. I'll pay the insurance. It's your car unless you get a speeding ticket. You get a speeding ticket and I will take this car back. It's mine. Your name is no longer on the title. Give me the keys. That would be defeasible. That would be defeasible ownership. It's this idea that, if you don't mess up, if you don't do what I said not to do, yeah, it's yours forever. But if you mess up, you could lose the title. And it turns out there's 2 types of defeasible estates. You got fee simple determinable and fee simple conditional. And that's also known as fee simple with a condition subsequent. And just to keep things simple so I can get to contracts, we know that with a conditional defeasible estate, the original owner would have to go to court to get ownership back. So I'd have to take my nephew to court. Right? A determinable estate is when ownership automatically transfers. So the second my nephew would have gotten a speeding ticket, it would have been mine. Now, obviously, you need an attorney, but people can do this with real estate as well. Yes, Lloyd, in a determinable estate, it is immediate. But in conditional, you got to go to court. And I know there's a lag and all of that, so hopefully that's not too bad. Right? So with defeasable, you could possibly own it forever. Just don't mess up. Well, then after that, you had number 3. You're never going to own it forever. And when we talk about that, we're talking about life estates. Now, just in general, when we say the word life estate, the word estate means you can live there. Right? So you can live there, and we're talking about a type of freehold estate, so that means you own it, but it's all about this word life. And it turns out there's 2 different types of life estates. Right? Those types of life estates, you got your regular, and you've got your pour attrivi. So a regular life estate, just a plain old regular life estate, you own it as long as you are alive. Right? That's the whole point behind a life estate. You own it as long as you are alive. You are the owner. And I'm going to do this right here. This you own it. That makes you the life tenant. And let's change this color here. As long as you're alive, we call that the measuring life. So in a regular old life estate, the life tenant and the measuring life, they're the same. In a life estate, the life tenant and the measuring life are the same. But in a pour attrivi, well, pour attrivi means for the life of another. So in a pour attrivi life estate, you own it until someone else dies. So you've got your idea that the someone else dies. That is the measuring life. And then until you own it, that's going to be the life tenant. Well, that's all well fine. Oh, good. That makes sense. Good. And if you want me to give you a real life example, just let me know. Right? So I think that, you said it makes sense. Do I need to explain anything else? And Sierra, I saw that you asked about contracts. In the chat, put in there what it is that you are looking for as far as contracts. Like, is it vocab? Is there a specific word or anything like that? And I can see I have a number of people watching, so let me know. Is there another question that I can answer for you? Oh, and again, if you're one of the newer people here, I realize there's a lag. I'll work on that next time. That just means you'll have to have another free session at some point. I'll work on that lag and figure out what's happening. Oh, good. The light bulb went on. I'm so glad that light bulb went on. So just let me know. You said titles, please. Title title, like types of title. Tell me what you mean. You want me to explain, Sherry, what title is, or are you talking about give me some more, like you say title. What type of title do you want me to go over? And Sierra, if you're still there, give me some more on what about contracts. Vocabulary. Vocabulary contract for contracts. All right. Well, it seems to me you got some basic contract words. I'm kind of sick of this blue. Let's go with green. Now, I'm hoping that you know the difference between valid, voidable, void, and unenforceable. Because you know they're going to ask you about that. You know they're going to ask you about the difference between void, valid, voidable, and unenforceable. So let's start with valid. A valid contract just means it meets all the criteria. Now, I teach the criteria as MCLL, which means there has to be mutual agreement. There needs to be consideration. There has to be legal capacity. And there has to be a legal objective. As long as the agreement has all four of those, then you have a valid contract. And when you say a valid contract, that means, it's good. Like you agreed to do something, I agreed to do something, and it possibly could be enforced. And where a lot of people get this wrong on the test is whether or not it's enforceable. Oh, wait, why do I have unenforceable there? It's got to be, because that's the word. Losing my mind. It's a question about whether it's enforceable. So let me give you a good example of this, and that is the word that everybody loves, Statute of Frauds. Okay, that was just terrible. My handwriting is awful right now. Let's try that again. So the Statute of Fraud says certain contracts have to be in writing. Certain contracts in writing. Like leases over a year, or contracts that transfer an interest in real estate, like a purchase contract for a piece of land. If a contract where one person is giving a piece of land or a house or whatever it is to another is not in writing, it could be valid. It meets all the criteria. It meets the standard. However, it's not enforceable because the Statute of Fraud says, hey, in order for us to follow this up in court, because in my opinion, when you take somebody to court, you're basically tattletelling. And don't tell me I'm wrong there, because I know I'm right. We have this concept of when somebody does something wrong, you go and you tell the judge and you want them to make it right. Just like if you have siblings, somebody hits you, you go to a parent or a grandparent or aunt, whatever, and you want them to make it right. So you go sue. And when you sue, usually you're looking for them to enforce the contract, make them do what they said they were going to do. So the Statute of Fraud says, okay, look, if this is going to be enforceable, it needs to be in writing. It's still valid. It's just not enforceable. So we know the Statute of Fraud says certain contracts have to be in writing. Well, then what's the difference between valid and voidable? Well, voidable means it looks like it's a contract, but maybe a party can get out of it. When it's voidable, there's something going on where if you can show the judge that, oh, this thing exists, then they are not going to, they're going to say, you know what, never mind, this isn't a contract at all. So for example, let's talk about something like duress. If you know about duress, duress is when you sign a contract and you didn't want to. You were doing it because somebody was threatening you, right? Maybe I held a gun to your head or something like that. That is duress. And after you sign that contract, let's say I'm threatening you and I make you sign a contract. When I walk away and I have that piece of paper, it looks like, and it is a valid, enforceable contract. However, if I didn't know that maybe you had a recording, whether it was audio or video, and you can prove to the judge that the contract was done while I was threatening you, well, that's a reason for the judge to void it. So it could become voided. It is voidable because a valid contract, for the most part, can be enforced at some level, right? But a void contract was never a contract. A void contract was never a thing. If you had two 9-year-olds where one 9-year-old said, hey, I'm going to sell you my house, and the other 9-year-old said, hey, I'm going to buy your house, and they put it in writing, nobody would think that had any legal effect at all. And that's because it's a void contract. It never met all of the criteria to be a contract, because they weren't of legal age. So I'm hoping that makes sense. Just remember, voidable means maybe a person can get out of it. Maybe it can become void. Right? And void means it has absolutely no effect. Absolutely no effect. So I always think that real estate and dating kind of go together. Imagine an ex that you hated asked you to give them $10. That has no effect on you. None. Zip zero. Can't force you to do it. You don't even have to pay attention to it. It doesn't even exist. It's like that person didn't even speak. That's void. Oh, I'm sorry. When you broke up with me, you voided my ability to hear or do anything that you just said. Void. A void contract it's almost like a misnomer because it's not a contract. It's just something that somebody said or did or wrote down, but it has no legal effect whatsoever. So I'm hoping that clears up the contracts for you. And then I saw, Sherry, you were asking about equitable title. Equitable title. So let's talk about title. We know title equals ownership. And we just learned about ownership is freehold, right? But title it's your right to own something. And when you own something outright, you know, if you have a fee simple, absolute, then you would own it legally. You own it legally right now. It's yours. You have the deed. You have the ownership. That when you get fee simple absolute, that's what you have. You own it. It's yours. However, sometimes you decide to sell it. And when you decide to sell it, so let's say you have person A and they have this house and they want to sell that house to person B. So what do? They sign a contract. And yes, I know I can't draw. Just leave me alone. When they sign that purchase contract, then the deed, and I'll use a different color for that. The deed, let's try that again. That deed is right there with the original owner. But then when it closes, once you close and you do settlement, then that deed transfers over here. And then the new person would have the deed. Legal title. This is legal title. That deed is legal title. And B has the right to claim this later. So let's say they signed this on October 1st, and they said closing was going to happen October 28th. That means person A cannot sell it to somebody else. Person A said, I'm going to give you legal title in 28 days. That is person B's right to own that house. Person B has the right to own it. They have the right to claim it later. And you know that if person A tries to back out, person B could take them to court and sue them for specific performance. What is specific performance? It is the judge forcing you to go through with what you said you were going to do. Why? Because it was a contract, and that contract was in writing, and it was a transfer of interest in real estate, so it's enforceable. Ta-da! So it all kind of goes round robin. If I had one piece of, I guess I should say this. So equitable title is the right to claim it later. It's when the house isn't yours yet, but it's gonna be, and you have the right for it to be. Right? That's equitable title. So one piece of advice I would have for all of you all is don't just learn your vocab. I want you to connect your vocab to something, to other vocab. Well, what do I mean by that? I definitely do tutoring sometimes, and I see people who know the material, and I'm going to say they recognize the material. It feels like they know it, because if I ask them a vocab word, they'll say, oh yeah, I know what that means. But they have no idea where it fits into the puzzle that we call real estate. Like if I said hypothecation, hopefully you would know that hypothecation means somebody, a borrower, has pledged property as security for a loan, but they didn't give up possession. Now, I know this is a real estate class, but think of your car. If you've ever had a car loan, you were using the car. The car was in your possession, but you know if there's a car note, that's the bank's car. That's why they can come and repo it. Right? So hypothecation is this idea that, you've pledged the property for collateral, for a loan. Well, that's great if you know that, but why do we care? If all you know is that, then you just learned a word, and it's not going to stick with you because it doesn't mean anything. Like you're like, okay, yeah, that's great. It doesn't have any effect. I like to tell people, think about what other vocab it goes to. And I see you, Sherry, you said like title theory. Yes, title theory definitely has to do with your different title theories like that. But it has to do with loans, right? And so you need to know about it because it has to do with title and lien theory. It's how somebody is able to stay in their house even though they have a loan. Even though when they borrowed money to get that loan or to get the house, they said, hey, you can take my house if I don't pay you back, but they still get to use it. I guess the best way to talk about it is in contrast to like a pawn shop, right? So if you need $500, you could go and maybe you have a great guitar and you could say, hey, pawn shop, I need $500. They're like, great. You give us the guitar. You're going to leave the guitar here, and when you pay us back the $500, we'll give you the guitar back. There's no hypothecation there. You don't get to take the guitar with you. But when you say to a bank, hey, I want $200,000 to buy this house, the bank doesn't hold on to the house. The bank says, okay, you live there. We'll let you use it as collateral, but if you don't pay us back, we're selling it. And the difference between title theory and lien theory is when the bank either gets title like a car. So in a title theory state, you're actually using a deed of trust. That buyer is transferring title to the bank, really the trustee, the trust. And in a lien theory state, the borrower keeps legal title and the bank only gets to put a lien on the property, right? So hopefully that makes sense. If it does, give me a thumbs up. If it does, give me a thumbs up. And I just want to do a little test because I know that there is a lag. So I'm going to say, at this second, I'm going to wait for my clock to turn and I'm going to see how bad the lag is. Oh, and also put in your next question. So my computer is saying, oh, there we go. 6:32. It looks like a 30-second lag, maybe? I'll definitely have to fix that. Definitely have to fix that. I don't feel like it's this long when I do the webinars. So I will see what's going on. But give me your next question. I know you've got questions and I am here to answer them. And if you were at the webinar today, I do believe I do owe you something. And so for those people that missed it today,
good job, good job, good job, good job. T-double-O-D-J-O-B, good job, good job.
So there you go. You all did a great job today. I absolutely, positively loved how many questions that you got right. Also, if you don't have any questions, tell me, what is it that we can do as prep agent or I can do as an instructor or teacher or guide to help you study, to help you pass, to help you get a better understanding? I see you, Sherry, and I see you, Princess. Let me know. Let me know. What is it that I can do or I can suggest that we do so that you feel even more confident when you go in to take this test? Don't be shy. Go ahead and ask me. I know this lag. We're going to have to fix this lag. So as long as there's lag and you're putting in your questions or your suggestions, I might have to do this again. I know I mentioned that, but maybe tomorrow or something like that, I can come in and I can see if I can fix the lag. And then Princess, you said, can I talk about market analysis? So are you talking about a CMA? Or are you talking about, so we know a CMA is a, why can I not think of what the C stands for? Lord Jesus, I'm losing my mind, y'all. I have lost my mind. But a CMA is what we do as agents. And it's designed to tell our clients either, how much we think they should put an offer for or how much they should list the house for. Right? So that CMA is based off of the sales comparison approach, or some places they call it the market data approach. So when you say talk about market analysis, when I'm thinking pre-licensing, you all trying to get your license, this is what I think of when you say like market. But if you all had already gotten licensed and you'd said, okay, can you tell me about market analysis? I would be thinking about the now market. Like, is it a buyer's market or a seller's market? I'd ask about things like days on market. I'd ask about the absorption rate. So that's all training stuff. You will get this information when you get a broker. Right? So give me some more competitive market analysis. There you go. Thank you very much, ma'am. And, I was going to say, Sherry, you asked, when's the best to do private tutoring session? A few days before testing or just a day or so before? Well, you know what? It really depends. And I'll say that because, and I know I always saying it depends. Before you take some private tutoring, what do you want? What I mean is, what do you want out of it? So sometimes people will set up a private tutoring and they'll say, I just want to understand more. Okay, this is a big class. You got to narrow it down. You got to tell me where you're struggling. So I think people take these tutoring sessions at 3 different times. One, they take it while they're in class. Or 2, they take it after class with time before they take the test. Or 3, they take it right before the test. And I really do think it depends, like when you should take it. I love when people take it while they're in class, because what I can do is help you learn how to study. That's what I've discovered in 15 years of teaching. It's not that people are stupid or they're just not trying. It's a lot of information, and a lot of people are not studying effectively. So the awesome thing is, when I can get my hands on you earlier in the process, I can help you take better notes, come up with ways to study so that you're not spinning your wheels. Whenever you take a class after, take a tutoring session with me after you pass the class, well, then I help you come up with a study plan that really basically teaches you what you need to study and how you're going to study. And then right before the exam, that's when you come with clarity. You're looking for me to give some clarity on a topic. Now, it's not that I can't give clarity during the other times. It's just when it's right before your exam, you just want to get some answers and kind of put it all together. So, it just depends. I like when people come to the sessions and they know what it is they're trying to get out of it. So I hope that helps, right? So, and Princess, you said cost approach, gross rent multiplier, and income approach. Well, all of those, we know that the cost approach, and I just want to make sure, I'm going to change the setting on this iPad so I don't have to do left. In an appraisal, there's 3 methods. You got the sales comparison, you got the cost approach, and this is also known as the market data, and you have the income approach. And the reason I'm laying this out is because under the income approach, you got 3 ways you can find value, or that appraiser finds value using the NOI and the cap rate. Or there's the GRM, the gross rent multiplier, or the GIM, and that's the gross income multiplier. So, I don't know who this person is, but they got to go. We're going to delete them and remove. So, I hope that helps, Princess. I don't know if you, if that kind of was what you were just trying to, make sure that's right. But I've got to go teach I've got to go teach a training class for a company. I'm going to be helping new agents figure out what they need to be successful. So let me know, and I know there's a delay again. I'm going to fix it. Would you all be willing to do this again if I pick a time and we work on the delay and I give you the opportunity to ask me some questions? And if you want, you can even ask me some math questions and I will work them out. But I really appreciate this. You all, we got the sound working. That's awesome. I know there's a lag. I can try to fix that. But just suggestions. And thank you. Thank you so much for giving me your time tonight. Oh, Sherry, you're so welcome. You're so welcome. I think, I don't know. I wonder if the lag is also with the chat. Oh, you love that? Well, Sherry, look, I appreciate you being here, your time. All of you all that are here, thank you, thank you, thank you, thank you. I want it to work well. So I know you all found this because you were in the Facebook chat. Oh, I forgot to check my email in case somebody wanted to do it. So you know what? Now I'm going to have to email those people and say I have to do it again. So this will happen again, where it's either going to be tomorrow or maybe Saturday, just because I want to make sure I give everybody this opportunity. And if you like it, maybe we'll do it a little bit more regular. So I will see you or hear from you next time. Keep watching the Facebook group, and I am so proud of y'all. So I'm going to end it with a
Good job, good job. Good job, good job. TOODJOB, good job, good job.
thanks, everybody, and I will talk with you next